Legal thought and legal education are ready for revolution. Our interests and ideals are always nailed to the cross of the institutions and practices that represent them in fact. The site of this crucifixion is the law. In law, spirit meets structure. Here are 5 aspects of the present circumstance that make such a revolution both possible and necessary. The first aspect has to do with the mismatch in legal education between the work and the constituency. In many places of the world, people go to law school to learn what the deal is in their society and to master the discourse in which this deal is represented and revised. That's what they look for, but that's not what they get. For the most part, what they get is a desiccated doctrinal formalism, a form of conceptual scholasticism that is neither theory nor practice. In the United States, on the other hand, and in a few other countries, the elite law schools have abandoned doctrinal formalism and expanded the scope of legal education. In expanding it, they have also emptied it, as I shall later remark. And yet, in the United States, the constituency of the law schools is overwhelmingly composed by people who intend to have legal careers, to be attorneys or judges or advisors to corporations. So you see, where legal education is narrow, the constituency is looking for something broad. And where it is broad, the constituency is looking for something narrow. This ironic mismatch between the task and the people reveals that the present circumstance of legal education is not functionally determined. It is the result of a series of historical accidents and misdirections. The implication is that there is an enormous space for reconstruction. The second aspect of the circumstance has to do with the hollowing out of legal thought and legal education in precisely those parts of the world in which doctrinal formalism has been most unequivocally repudiated. In the elite law schools in the United States now, for example, the typical topic of discussion in the classroom is what to do about the problems of society. Law becomes just the pretext, the point of departure for a policy debate among the insiders. This discourse is, for the most part, simply a continuation of the discourse of the newspapers, by other means, at only a marginally higher level. What shapes it? What directs it? What imposes limits on it? Absolutely nothing, other than the desire of the insiders not to become outsiders and not to find themselves painted into a corner. And what do the legal academics do in this circumstance? Seeing that the content of legal doctrine has been eviscerated, that it is harder and harder to believe in its presuppositions. They propose to import the content from outside, from all the social sciences. But the trouble is that what the social sciences have to offer is not what legal thought needs. Law is about the structure of society. As the German historist has said, the law is the institutionalized form of the life of a people. The contemporary social sciences are entirely bereft of any structural vision. They provide no account of how the structure is created or of how it could be remade. They supply a naturalizing patina, a mendacious semblance of necessity imposed upon the present arrangements. Not a practice of insight, but a surrender to superstition. So we need the content. We need an economics, but not the economics that exists, some other economics. A way of thinking about politics and society, but not the way that is offered in contemporary sociology or political science. The third aspect of the circumstance requiring revolution is the existence today in the world of a very restricted repertory of institutional options for the organization of different domains of social life. In each area of social life, there is now in the world a very limited set of alternative setups described in the details of the law. This restricted repertory of institutional arrangements is the fate of the contemporary societies. To rebel against this fate, we must enlarge the institutional repertory. And to enlarge the institutional repertory, we must reimagine it. And where will we find the materials with which to reimagine it? In the law, in legal thought. But law and legal thought are otherwise occupied. Not with the work of enlarging the institutional repertory, but rather with the work of giving it a halo. A fourth aspect of this circumstance relates to the false appearance of progress in legal thought. What is to follow the doctrinal formalism of the 19th century? According to the views that prevail in the legal professoriate of the United States and of the Western European countries, what should follow doctrinal scholasticism is an idealizing representation of law in the vocabulary of impersonal policy and principle. Is this the wave of the future? Is this what the rest of the world should adopt as the path to advance in legal thought? No. This is simply the reconstitution of the old doctrinal formalism in a different form. The two dirty little secrets of contemporary legal thought are, first, fear and loathing of the people, refusal to let law become the instrument of democracy, and second, right-wing Hegelianism. The belief that the real is rational, the attempt to represent the contradictions and disharmonies of law as a fallible imperfect approximation to an intelligible and defensible plan of social life, rather than as the point of departure for reimagination and reconstruction. The fifth aspect of the circumstance has to do with the relation between crisis and change. The content of contemporary law and the project of present legal thought are primarily the continuation of the last major institutional and ideological refoundation that took place in the advanced societies of the North Atlantic world. This was the social democratic settlement of the mid-20th century, described in the United States in the vocabulary of the New Deal. According to the terms of this settlement, the forces that proposed to reshape the worlds of power and of production renounced this threat, and the state was allowed to acquire substantial authority in the sphere of compensatory redistribution and of regulation. Now, none of the fundamental problems of the contemporary societies, richer or poorer, can be solved or even addressed unless we reopen the terms of that settlement. And what do we have, in fact, in the recent history of legal thought and of legal education? There are characteristically three moments. First, there is the volcanic moment, the moment of crisis, in which the jurists appear as technical assistants of those who are designing the refoundation. Then there is the long cooling down period, in which the work of the jurists becomes to routinize and generalize the terms of the settlement, to translate them into a system of legal ideas. And then comes the third moment, the moment in which we find ourselves, the moment of the fading light. The settlement becomes more and more ambiguous and contested and unable to speak to the fighting issues of today. And then the jurists tried to revive it by appealing to theory. Theory becomes a kind of bloodless proxy for the struggles and the compromises of another age. Early on in Tolstoy's novel War and Peace, the protagonist, Pierre, looks up into the sky and sees a meteor, Halley's Comet, visiting the Earth before Napoleon's invasion, and understands it as a presage of the great upheavals which will sweep him out of the long littleness of life into an intense and surprising existence. What are we to do if our lives do not happen to fall at the moment of the visitation of the comet? Should we just stand and wait? Should we sing in our chains? Or should we learn how to do without the comet and become our own comet, our own crisis, understanding that the task of the imagination is to do the work of crisis without crisis? For all these reasons, we need revolution in legal thought and in legal education. The temporizers who are in charge around the world will not undertake this revolution. You must therefore do it yourself.